Hi friends, I welcome you all to today's discussion with regard to finance related current affairs for upcoming RBI Grade B 2019 and SEBI Grade A 2019 examination. The topic which we are going to decode today in the form of MCQs is the recent current affairs portion pertaining to the Insolvency and Bankruptcy Code. So there were some of the news items which were there in the news pertaining to this particular code. So we are going to talk about the conceptual framework with regard to the current affairs which were there in the news, and also talk about the current changes which have been made through this particular discussion. Now friends, if you are a paid subscriber of our courses, you need not watch this video again, as the entire discussion is already included as a part of your paid course along with these MCQs. Now before proceeding forward, let me quickly tell you about the excellent results that we have achieved over the past few years. Now in 2017, in RBI Grade B, we had 27 final selections from our students, and in NABARD Grade A, we had 11 final selections from our students. And in 2018, we repeated the same success story, and in RBI Grade B, we had 70 plus final selections, and in NABARD Grade A, we had 26 final selections. Also, in 2018 SEBI Grade A examination, out of the total 84 selections, 41 of our students they made it to the final list, and in the IBPS AFO examination, our students have got 100 plus interview calls. Now, if I talk about the different individual courses that we are providing, then they include RBI Grade B, SEBI Grade A, NABARD Grade A, RBI Assistant, and IBPS AFO examinations. Now, apart from running the separate courses for all those individual examinations, we are also having some combo courses which you can avail. So we have a combo for RBI Grade B, NABARD Grade A, and SEBI Grade A. We are also having a combo for RBI Grade B, NABARD Grade A, SEBI Grade A, RBI Grade B, and NABARD Grade A and SEBI Grade A. So we have all the requisite combos that you can choose from, and you can choose the appropriate course as per your requirements. Let me also tell you about our new course, which is very important for all the banking exams. This is the QRE course. QRE, that is quantitative aptitude, reasoning ability, and English. So all these aspects which are very important for all the banking exams, they are going to be covered in this particular course. So let's start our discussion on the important MCQs which can be framed out of these current news items. First question, which of the following is incorrect about Insolvency and Bankruptcy Board of India? Options are, it was established on 1st of October 2018 under the Insolvency and Bankruptcy Code. It has a regulatory oversight over insolvency professionals, insolvency professional agencies, insolvency professional entities, and information utilities. It writes and enforces rules for processes, namely corporate insolvency resolution, corporate liquidation, individual insolvency resolution, and individual bankruptcy under the code, or none is incorrect. So friends, this question is basically about the conceptual framework pertaining to Insolvency and Bankruptcy Board of India. So friends, this board, it was established on 1st of October 2016 under the Insolvency and Bankruptcy Code. This board, it is a key pillar of this particular code, and now this particular code, it seeks to consolidate and amend the law which relates to insolvency resolution of companies, partnerships, and individuals, and that too in a time bound manner. So this particular Insolvency and Bankruptcy Code is basically concerned with resolving the insolvency situation in the country. It is a situation in which the entities, they are not able to pay their debts. Further, this board has a regulatory oversight over the different agencies, different entities which are to be constituted under the Insolvency and Bankruptcy Code. For example, insolvency professionals are going to be there, insolvency professional agencies are going to be there, insolvency professional entities are going to be there, and information utilities are also going to be constituted to act as a repository for different sorts of information under this code. Further, this board would write and enforce different rules pertaining to corporate insolvency resolution, corporate liquidation, insolvency resolution of individual and individual bankruptcy under this insolvency and bankruptcy code. So these are the important points with regard to the Insolvency and Bankruptcy Board of India, which we must remember. So friends, now we can easily answer this question that the first statement is incorrect because this board it was established in 2016. So answer is going to be option number 1. Next question. If a corporate becomes insolvent, corporate insolvency resolution process can be initiated by. Options are financial creditor, operational creditor, corporate itself, or either of the above. So friends, if you talk about the corporate insolvency resolution process, then this process is basically linked with resolving the insolvency situation of a company. So when such kind of a situation arises, the first step is to make an application to the National Company Law Tribunal. So in this regard, the application may be made by, or the corporate insolvency resolution process can be initiated by the financial creditors, operational creditors, or the company itself. The financial creditors would be the ones which have given long-term loans to the company. They would basically be the financial institutions. Operational creditors would be the ones who are basically connected with the operations of the company. They may be creditors for goods purchased by the company or any creditors for services availed by the company. So these creditors and the company itself, they may initiate this resolution process. So this corporate insolvency resolution process is basically the process through which it is determined whether it is worthwhile to run the entity, whether the person who has defaulted is capable of repayment or not in the future. If the person is not capable of repaying the debt of the company, then it has to be restructured or it has to be liquidated so that the situation is not aggravated in the future. So friends, now we can easily answer this question that the corporate insolvency resolution process can be initiated by either of the above. So our answer is going to be option number 4. Next question, which is our correct about the committee of creditors in corporate insolvency resolution process? It comprises all the operational creditors of the company. It informs the decision making body in the CIRP, both of the above or none of the above. So friends, if we talk about the different steps which are involved in the corporate insolvency resolution process, then the first step, as we talked about, is the application to NCLT by the creditors or the company itself. Then in the next step, interim insolvency resolution professional is to be appointed who is to take control of the affairs of the company, and a moratorium would come into effect on the legal matters and the transfer of assets by the company since it is under now liquidation process. Then the claims are going to be verified by the interim professional and a committee of creditors is going to be appointed, which is a very important component of these particular steps. Now this committee of creditors, it would comprise of all the financial creditors of the company. So this is very important. It forms the decision making body in this entire process. This committee is going to next appoint the resolution professional and a resolution plan is going to be put into place, and if it is accepted by the creditors then it's good. If it is not accepted, the company would go into liquidation. So these are the key steps involved in this corporate insolvency resolution process, and committee of creditors, we have to remember, it plays a key role in this entire process. So friends, now we can easily answer this question that the first statement is incorrect because it comprises all the financial creditors of the company. So our answer to this question is going to be option number 2. Next question. Liquidation Process Amendment Regulations 2019 provide for constitution of a stakeholders consultation committee. The committee would have representation from. Options are secured financial creditors, unsecured financial creditors, workmen and employees, or all of the above. So friends, if you talk about the salient features of the Liquidation Process Amendment Regulations 2019, then these regulations, they specify the process with regard to sale of corporate debtor or sale of the company as a going concern or sale of a business of the company as a going concern under liquidation. So Under liquidation, the company can be sold as a going concern or its business can be sold as a going concern. So the process with regard to this is contained in these regulations. Further, now this is very important, the amendments require completion of liquidation process within 1 year of its commencement. So this is something which we must remember. So in this regard, these regulations, they provide a model timeline for different tasks which are to be completed in the liquidation process. Further, the amendments also require the financial creditors, who basically are the financial institutions, to contribute even towards the liquidation cost where the company does not have adequate money, adequate liquid resources to complete the liquidation, and this is to be contributed in proportion to the financial debts. Further, these amendments, they also provide for constitution of a stakeholders consultation committee. This committee is going to be constituted to advise the liquidator on matters relating to sale of assets of the company. Now this particular consultation committee, it would have a very wide representation. It would have representation from secured financial creditors, unsecured financial creditors, workmen and employees of the company, government, other operational creditors and shareholders of the company. So these are the key features of the recent amendment regulations 2019, which we must remember from the examination perspective. So now we can easily answer this question that this stakeholders consultation committee would have representation from all of these. So our answer is going to be option number 4. Next question. National Company Law Appellate Tribunal recently held that options are shareholders and owners cannot reach a settlement with creditors when their entity is under liquidation and an official liquidator has been appointed by the insolvency court. Shareholders and owners can reach a settlement with creditors when their entity is under liquidation and an official liquidator has been appointed by the insolvency court. Shareholders and owners can reach a settlement with the creditors when their entity is not under liquidation and an official creditor has been appointed by the insolvency court. None of the above is true. So friends, this question is in regard to the recent ruling which has been given by National Company Law Appellate Tribunal (NCLAT), in which it has allowed the promoters under the liquidation, promoters of the company under liquidation, to settle with the creditors. So basically, this has come up as a new window for promoters who are looking to retain control of their companies which are basically facing the insolvency or bankruptcy proceedings. So in this regard, National Company Law Appellate Tribunal has recently held that the shareholders and owners, they can reach a settlement with the creditors when their entity is under liquidation and even if the official liquidator has already been appointed by the insolvency court. So this is basically going to allow the promoters that they could jump at this opportunity and retain the control of their respective companies while cleaning up the debt of their companies. So this is a very important ruling of NCLAT and we must remember this from the examination perspective. So friends, now we can easily answer this question. The answer is going to be option number 2. So guys, this was all about our discussion. If you are having any query, you can mail us at hello@edutap.co.in or you can reach us at 8146-207-241. You can call us or you can WhatsApp us. And I would also recommend that you visit our website www.edutap.co.in for regular updates and important content on the respective examinations. Thank you guys. I wish you happy learning and all the best from the entire team.